Lord, grant me patience. Lord, grant me patience. My lady, you are 52 now, and you would, God willing, if you are approved, when you get approval of this house, possibly through majority decision, you are likely to be on the bench for 18 years. My lady, at the time our Fourth Republic was birthed, would you say that upon attaining age 18, you registered as a voter, or the current registration where you registered Allah was your first?
I registered as a voter. I don't recall when, but this is not my first.
Very well, my lady. My lady, we have had elections since '92. We have seen two major political parties ruling the country. We've made some strides as a country. Within the sub-region, and I say this because my job has gotten me roaming the sub-region, and I say with pride that our country is far better in relative terms. As a Ghanaian, can you share with us some of the shortcomings of how we do our politics and views on ways to enhance it, to make it attractive to the citizenry?
Honorable Chair, I don't have any views on that.
Very well. My lady, did you pay attention to the data that was put out by the Electoral Commission regarding the 2024 elections, specifically the turnout, region by region? Did you pay attention to those data?
I did not.
My lady, do you pay attention to the current affairs of this country? Governance issues, what happens in Parliament, what happens in the executive space? Do you pay attention to any of that?
To the best of my ability, yes.
My lady, clarity. Clarity, I didn't hear you.
I said to the best of my ability.
You pay attention. Okay. Now, since you pay attention to the governance at the legislative level, the executive level, let's take it one by one. At the legislative level, how do you see the performance of legislative functions of parliamentarians, since you pay attention to what the legislature does?
I believe that you are doing exactly what you have been mandated to do and voted to do.
Thank you, my lady. My lady, are there ways that you think there can be improvements to enrich democracy? Can you make some few suggestions as a citizen of Ghana?
Thank you, Honorable Chair. I'm unable to make any suggestions concerning that because I am not an integral part of Parliament or the proceedings. So I don't think it will be in my place or proper to be making suggestions based on what I have seen and probably not everything that transpires. Thank you.
Well, my lady, as an observer who wants the good for your country, yes, without prejudice to being an integral part of the system, obviously you cannot be, you are not part of the legislature. But like you know, judges make their pronouncements and people, ordinary citizens, express their view. They may not be right, or they may not be seeing it the way you saw it, but it's their opinion. You say that for the legislature you cannot. Now, you've also been following executive governance. Have you any views to share regarding some shortcomings that you think can be improved upon?
Thank you very much, Honorable Chair. I do not have any views on the executive.
My lady, you are aware of institutions of state whose mandates provided for by the Constitution. You've observed them do their work. Have you any particular state institution that, in your view, you can make suggestions for the improvement of their work to enrich governance?
Thank you, Honorable Chair. I can say that, so far as I'm concerned, a lot of the state institutions are doing what they have to do. Some may be constrained by logistical needs, but other than that, I have no further comments.
My lady, as a judge, what are your peculiar challenges as a Court of Appeal judge? What are some of the challenges you face in the discharge of your duties as a judge that you believe call for reform to enable you do your work and do it well, having in mind even those who assist you? I'm referring to the court clerks and the registrar and all those in that value chain.
Thank you, Honorable Chair. As a Court of Appeal judge, we do exactly what we are supposed to do. We deliver our judgments as we should. We do our research as we should. But I believe that if we had legal research assistants or a pool of legal research assistants, that would also enhance efficient and effective justice.
Is technology enhancing justice delivery in our courts at all? And if so, do you have any suggestions as to how the system can be overhauled or improved to meet trends in modern justice delivery has been experienced in other jurisdictions?
Thank you, Honorable Chair. I believe that the e-justice system is going a long way to expedite cases in the courts in which it has been rolled out, and primarily the high courts. And so, in the high courts, proceedings, for instance, are typed in real time. In the high courts where the e-justice is rolled out in Accra, so as the judge speaks, as the lawyers speak, proceedings are typed. And the lawyers can access their proceedings speedily to ensure that they write their addresses on time. The judges are also able to access proceedings. And court orders are also expedited. So, I mean, insofar as the e-justice system is concerned, it is helping in efficient justice delivery. And if we are able to roll it out to other courts, I believe it would help.
My lady, I want to pick your thoughts on some issues. I don't see them as controversial, but it may be controversial. I'm going to focus on intersex persons, those born with both male and female sexual characteristics, and the discrimination they face in Ghana. Particularly, I bring these issues up to look at legal protection, gender identity, public policy, and the duty of the states under Article 17, 15, and 21, as well as 33 of the Constitution. Of course, Article 33 dealing generally on enforcement of human rights. Now, my lady, on the recognition and legal identity, I want to know from you, what constitutional or legal protections exist for intersex persons in Ghana, and how should the law respond to their unique identity challenges, particularly in contexts where they are forced to choose one gender on national forms such as passport or school admissions?
Thank you, Honorable Chair. I believe that every child at birth is assigned a sex, and that is what that child uses throughout their adult life. And so insofar as the person is assigned a sex as male or female at birth, I believe that the identification given to that person would prevail. And so in school, the child will be identified by a sex as male or female. And I believe that is what runs through. Thank you.
My lady, upon your careful reading of our Constitution, the 1992 Constitution, do you think that the Constitution has any protection for the dignity and the bodily autonomy of individuals born with both male and female sexual organs, particularly in cases where irreversible gender assignment surgeries are performed at birth without consent?
Thank you, Honorable Chair. The Constitution offers general protection for all parents. And so if, as you have stated, a gender reassignment surgery is performed at birth, then it would mean that that person at birth has a sex and is identifiable and is covered by the Constitution.
Now, my lady, I want to know about some legal remedies or judicial protection. So you have already emphasized that Article 33 provides those general protection of our rights. But such individuals that we are referring to, you talking about, face some form of discrimination, some form of stigmatization. As a judge, knowing that the Constitution provides this broad spectrum of protection, what would be your position should those who are intersex persons face exclusion, ridicule, or denial of services because of their condition? And how effective are these protections under the current legal framework, in your view, can best be ensured? What views can you express to help safeguard some of these guarantees in the Constitution?
Thank you, Honorable Chair. Now, an intersex person is born as they are. So it is not a choosing. And the Constitution guarantees freedoms for all persons under its reach, that is in the country. And insofar as I'm concerned, I do not see that the Constitution is discriminatory of intersex persons, because these are persons who do not choose their sex. They are born that way, and they are protected, in my view.
Well, my lady, I will lift my next question from where you ended, that intersex persons are born with it. They don't choose. But we are equally aware that there are some social and institutional marginalizations that exist. We cannot pretend about it. As a judge, sitting in a constitutional court, would you consider some constitutional, legislative, or administrative reforms to ensure their recognition, dignity, and inclusion in national life? Would you look at it?
Thank you, Honorable Chair. I believe they are covered, as I have stated. And so to my mind, there is no further need to find special legislation for them.
My lady, by way of follow-up, if you say to your mind they are already covered, so there's no need to provide specifically for them, can you specifically give an example? I mean, if you say they are provided for already, what do you mean by that?
Thank you, Honorable Chair. Now, the Constitution guarantees freedoms and rights. The right to hold property, the right to liberty, so many other rights, except as limited by law. And these are rights that are also enjoyed by intersex people. And I do not see any need for specific legislation in that regard.
My lady, just by way of clarity, it is your case that the Constitution does not place any limitation on such rights as those intersex people are expected to enjoy, correct?
I do not see. Thank you, Honorable Chair. I do not see any limitation insofar as the rights provided under the Constitution are concerned.
Thank you, my lady. I think we're done with that bit. We'll conclude on the very last part of a set of questions, and I'm going to basically look at Article 21, 1C of the Constitution, which guarantees freedom of religion. And I have specifically framed the questions around the practice mission-owned schools, particularly Christian and Islamic schools, where students of different faiths are sometimes compelled to attend religious activities that may contradict their own beliefs. Now, if you look at the nature and scope of religious freedom, Article 21C of the Constitution guarantees freedom to practice any religion and to manifest such practice. Now, would compelling a student to attend a religious service contrary to their own faith violate this constitutional provision?
As I look at the provision, it grants the freedom to practice any religion and to manifest such practice. Insofar as the students are permitted to practice their own religion and manifest the practice, I do not think that there is any infringement.
Yes, my lady, that is understood. That comes without doubt, and there is no ambiguity on that. But my question is, would compelling a student to attend a religious service contrary to their faith violate this constitutional protection? I'll give you an example. I am a Catholic. I attended a Catholic school. But in St. Augustine's, it was mandatory for every student to attend Mass. And my Muslim brothers, my Pentecost, Methodists, SDA, were all compelled to attend this compulsory Mass. What I'm asking is, in such a situation, do you see any violation of these constitutionally protected rights?
Thank you, Honorable Chair. I do not.
My lady, why? You are being compelled to practice a faith contrary to your own. My lady may explain to us. We learn it, please.
Because rights are not absolute. Every right has its limitation, including being limited by the rights of others and the public interest. So, for me, if you are in a Catholic school, having chosen a Catholic school, knowing it is a Catholic school, and you are in a Catholic school, and the code of conduct requires that you do certain things, and you were informed prior to it, and you still chose to attend, then to me it would mean that is not compulsion, because you were made aware, you were informed that when you come to this school, this would be our code of conduct, and you chose to go to the school. So it's not a compulsion, it's a voluntary act, because before you came to the school, you were told that this is a Catholic school, would expect you to go to church on Sundays, would expect you to do this. And you took that voluntary decision to attend the school. And so I do not see that it is compulsion. Thank you.
My lady, having that in mind, would you say that as part of still ensuring respect for 21C, such institutions should also provide for opportunities to enable other students to practice their faith alongside complying with the specific standard practice?
I believe so. I believe so. I think they should create that opportunity.
Very well. But in creating that opportunity, it doesn't come as of right. Or you are anchoring it in terms of guaranteed rights. Is it a matter of discretion or some moral accommodation or something?
It is desirable. It is desirable.
My lady, the concept of desirable, can you expatiate? Some of your law students want to understand you.
It is desirable in the sense that it is a good thing to do. It is a good thing to do, and it's an appropriate thing to do.
So you will not bring it under the general scope of 21(1)(c)?
Not at all.
Very well. Fair enough. My lady, in your view, does the fact that a public school owned by a religious mission grants it the right to override constitutional religious freedom of students, in view of what you've said earlier? I just want a clear position.
The situation, Honorable Chair, thank you. The situation is this. The school is not compelling you or insisting that you do anything that you haven't voluntarily agreed to do already by attending the school, because you are told beforehand that this is what we do. You will go to church and you decide to attend the school. So it's a voluntary decision. Now, if you are of the view that it is a compulsion, I believe that there's a forum for that. So the matter can be taken up for the necessary decisions to be taken and then to guide us.
My lady, from what you have said so far on this matter, is it okay for me to come to a conclusion that requiring students to participate in religious gatherings that contradict their beliefs will not amount to any discrimination under Article 17 of the Constitution?
Insofar as I consider it not as a compulsion, I do not see that your freedom to practice your religion is being infringed upon. Thank you.
My lady, let's deal a bit with parental rights and religious autonomy. So many parents have very strong views. Should parents have the right to object when their child is compelled to attend religious activities in schools? And in situations like that, what is the best approach for the courts in handling this? My lady, just to take you and I back to a matter that happened recently, you recall this case where a twin, a boy and a girl, they had admission to Achimota, and Achimota had their own standard. They were Rastafarians, and Achimota required of them to take their Rasta, and they went to the courts to enforce their rights, and the court made some findings against the school and upheld their prayer, and they had to go back. Those were not religious rights, but I felt I should tease that out, generally. I mean, in view of your earlier position that once you subject yourself to it, some hospital praise against you, you will not now be talking about your fundamental rights, etc., etc. In view of that, do you think that parents who find themselves objecting to said compulsion have any such rights? And if they do, what is the best way for the court to address it by still maintaining some harmony between them and the schools?
Thank you, Honorable Chair. I believe that everybody has a right to proceed to the law courts if they feel that some right of theirs has been infringed. So the courts are available for that. Now, when you go before the court will look at the circumstances of the case and decide whether or not indeed your right has been infringed upon and whether any remedy should be made available to you. Thank you.
My lady, I noticed that you alone, you have two different brands of water, Awake and Belakwa. They give you two. The clerk must be very magnanimous. And we have only Awake with us. My Lord, all three. My Lord, just to let you have some breather, we are done soon. Just 2 or 3, we are done. My lady, the duty of the state in religious neutrality. What constitutional obligations, in your view, does the state owe to ensure that educational institutions, especially those receiving public support, do not infringe on students' religious rights? Emphasis, public support. It may be a religious or missionary school, but taking state funds.
Thank you, Honorable Chair. I believe that the GES has guidelines and regulations for the schools, and so that would be enforced within the schools. Thank you.
Now, my lady, on the issue of balancing institutional tradition and individual rights, some have argued that religious practice is part of cultural heritage of mission schools. And they are very strong in these views. How should a court balance institutional traditions with the individual's right to religious freedom?
I believe that a necessary determination will be made when the matters are brought to the courts. Thank you.
My lady, this question will be conditional. Conditional in the sense that if you are aware of precedents, if you are not, I'll just move away from it. Are you aware of any case law in Ghana or comparative jurisdictions where the courts have ruled on compelled religious observance in our schools?
I'm not aware.
At all in Ghana?
I'm not aware.
Zero?
No, I'm not aware.
Okay. My lady, you may want to check. Is that okay? Would you be fine? Since you are not aware, just
I didn't
check whether there is any such precedence. Your answer is that you are not aware of any precedence at all in our Ghanaian judicial system, where we've had the court ruling on compelled religious observance in our schools.
I'm not aware.
You are not. Very well. Well, let me ask you something on faith-based morality and constitutional pluralism. Should a faith-based school be permitted to justify compulsory religious attendance on moral or disciplinary grounds, even if it infringes on the student's religious identity? I'm mindful of your earlier position that was on the fact that the person has chosen to be in a particular environment well aware of certain conditions. But this is looking at a broader scope.
Honorable Minority Leader, the nominee has said that GES has their guidelines and rules on this matter.
Mr. Chairman, let's end it well. I heard that the mainstay of this question is whether or not those faith-based schools should be permitted to justify the compulsory religious attendance. She gave an answer in respect of general guidance, but you and I know, Chairman, please bear with me. You and I know that they've also made several representations to provide justification. I am asking whether or not you hold a view that such justifications, especially on moral or disciplinary grounds, be permitted. I've qualified them. I've qualified them. That's why I said these are broader in scope. I've qualified them on moral and disciplinary grounds.
Thank you, Honorable Chair. They are entitled to make their justifications. As to whether or not it is acceptable will be for the regulator to decide.
My lady, you've already told us, and this is my very last question to you. You've already told us that to the extent that a person chooses to be in a school that enforces certain religious rights as opposed to his general rights under 21(1)(c) are impliedly terminated. That being the case, can you share your thoughts on how, in spite of all of these, the judiciary can play a role in protecting students from religious marginalization in public or mission-assisted schools?
Thank you, Honorable Chair. What I said was that the fact that a school has asked that you worship in a certain kind of way does not prevent you from worshiping in your own way. And I was asked whether it was a good thing for opportunity to be granted to them to worship in their own way, and I said yes. So there's no prevention from worshiping in your own way. So it is desirable that you be given the opportunity to worship in your own way. Now, what the judiciary will do will depend on what has been brought before the judiciary. Thank you.
My lady, now, yes, on that set. Now, there are young girls coming from that part of the region where you come from. Many of them placed at the lowest ebb of fortune's wheel. They are watching you. They have seen you rise on the social ladder. Today, I'm sure some of them may shape their opinion, seeing a woman being elevated to the Supreme Court of our country. You have earned it through your own patience and industry. You've risen to eminence by merit, and I'm sure you are respected among your equals. Can you share your thoughts on your journey to this high pedestal with that girl child out there, and say a word or two to inspire them that nothing is impossible? And that will be all for you, my lady.
Thank you very much, Honorable Chair. I would like to tell the girl child, as I have been asked, that with hard work, perseverance, and God on your side, you can reach the heights that you dream of. And nothing is impossible unto God. So they should continue to work hard with determination and integrity, and they would reach the heights and even beyond what I have reached. Thank you.
You can say that in your local language to them, because I want you to address your locals. Is that okay? Maybe you said it in English, in brief, just to...
Minority Leader, the rules are very clear. It is only when you say something in a local language that the rules enjoin you to translate it in English. In this case, having said everything in English, there is no rules that allow you to then translate the English into a local language. So please, you are not permitted to do that. We've come to the end of your vetting. I will give the floor to my Vice Chairman to do the needful.
Thank you very much, Chairman. As you rightly said, we've come to the end of the vetting. The nominee came with friends, family, and colleagues, and we would like to acknowledge them. First on my list is Mr. Amaleboba, Esquire, I believe is a spouse, and Mr. Abdul Latif Isifu, Mr. Suleimana Osman Saka, Kompini na Bukari Yahaya, Kompini na Alaji Said Isa, Mr. Fawzi Isifu, Ms. Faida Isifu, Dr. Nicholas Atampukri, Madam Gloria Owusu Afra, Dr. Erica Ntiamuamensa, Professor Samuel Atinton, Dr. Andrew Akola, Colonel S. Babila, retired, Mrs. Juliet Babila, Mr. Wahid Pampori Idrisu, Esquire, Mr. Philip Jimano, Esquire, Justice Christopher Archer, Justice Samuel Obin Diawu, Mr. Andrew Stete, Esquire, Alayi Sipro Yusuf, and Weri Nabali. And we have the Acting Chief Justice with us and other justices. So that's the end of the French family and colleagues who are here to support the nominee, and we acknowledge them. Thank you very much for coming. I hand over to Mr. Chairman. Thank you.
Honorable members, as indicated, we've come to the end of the vetting. We thank the nominee for attending upon the committee and answering questions. You will hear from the committee, and you are hereby accordingly discharged.
Thank you, Honorable Chair.
Someone